Mr. James, I understand you're going to begin.
Chief Justice, may it please the court, counsel. My name is Christopher James, and along with Bill Hannigan, we represent the appellant, Little Sioux Corn Processors, or Little Sioux, in this case. We respectfully request this court reverse the district court's opinion and find that the replacement tax, as codified in 437A.5 subsection 2, is unconstitutional under both the equal protection clauses of the Iowa and U.S. Constitutions and under the Dormant Commerce Clause of the U.S. Constitution as well. The replacement tax violates the Equal Protection Clause by imposing drastically different rates of tax on similarly situated taxpayers with no rational basis. In fact, it makes no sense to tax two similarly situated taxpayers under drastically different rates based solely on historic property tax values and taxes paid that have no relation to the taxpayers in this case. In fact, the consumers in this case that are being taxed on their therms of natural gas are an unintended consequence of the replacement tax. The replacement tax also violates the Dormant Commerce Clause as well because it imposes a penalty upon consumers that choose to participate in the interstate pipeline versus those consumers that take their gas from the local distribution company of natural gas. There's also a statute of limitations that is contained in the replacement tax in 437A.14B1. And that statute of limitations is quite remarkable. It has a 3-year normal kind of tax refund provision for statute of limitations. But then it says if you have a constitutional claim, it has to be brought within 90 days of the tax being paid. And you can only bring it within 90 days if you file a written statement as a precondition when you pay your tax. So there's an immediate statute of limitations that's only for the constitutional violations that are brought to the state's attention. Little Sioux Corn Processors is a producer of corn-based ethanol, and it's located in Marcus, Iowa. It uses natural gas in the process of converting corn into ethanol. It receives its natural gas directly from the interstate pipeline, rather than from a local distribution company, which in its service territory would be Mid-American Energy. When it takes directly from the interstate pipeline, that's called directly connecting or bypassing the LDC. So a directly connected consumer or a bypass consumer. Because Little Sioux is directly connected to the interstate pipeline, it's subject to a tax under 437A.5 subsection 2. And that is a tax directly levied on consumers. The facts relating to how the tax works and how the tax was set up is relevant in this case to understanding the equal protection analysis.
Let me just ask you, how would you structure this excise tax to make it constitutional in your view? What would be, give me an example of a constitutional excise tax.
Of a constitutional replacement tax?
Yes.
Okay. I think that the way it works in LDCs is constitutional. The department, and I think to a certain extent the district court, misinterpreted our argument that we are attacking the whole of the replacement tax. Well, the replacement tax involves the production of electricity, which we have nothing to do with. The replacement tax also in subsection 1 of 437A.5 is directly imposed on these providers. And I think it really just needs to be on the providers of natural gas.
So in other words, anything, if you had to pay any tax at all, that would be unconstitutional.
I think that we would pay tax. We would pay a property tax upon the property that's used to transport our natural gas. So Little Sioux Corn Processors has a pipeline that connects to Northern Natural Gas Pipeline, and that would be subject to local tax and the property tax, and that's what we would prefer.
Right. But didn't you get property tax incentives in order to locate in Cherokee County and open the plant? Didn't you get relief from property taxes? And I thought I saw that in the record.
There were some time-limited property tax abatements at the time that.
And what makes those constitutional?
In terms of vis-a-vis other taxpayers that may pay property tax?
Correct.
Well, I think this, I think the court and through the Economic Development Authority has authorized certain kinds of tax incentives and tax abatements. And those have routinely been upheld as far as constitutional scrutiny is involved. And that involves...
what's the underlying reason? What would be the rational basis there?
Well, for one thing, you're talking about a local jurisdiction. So that's a tax that's levied in a local jurisdiction based on their local government needs and local government rationale. Local electorate has a voice in that. And in this case, what you have is these state set up arbitrary competitive service areas that...
But isn't it kind of similar in a way? I mean, what happened, at least if one takes the legislation at face value, is the General Assembly across the street had to weigh different interests and different political concerns and came up with this compromise that was intended to preserve expectations. And isn't what's different about that is a rational basis and what you're arguing for your client's own tax relief?
Sure, I think that there's a fundamental difference between different tax incentives and then a tax that's actually imposed at widely very different rates throughout the state from a state level. In fact, that's something wholly unique to this tax. For other types of tax incentives or tax differences, what you see is that's delegated to the local jurisdictions that have, and I think to a certain extent, what this court has said in other cases is that when you look at the local jurisdictions, they have local needs that you can that are taken into account. Here you have a state level tax that's actually imposed. So we're not talking about exemptions versus not being exempt. We're talking about the fact that two different ethanol plants can be taxed at drastically different rates. In fact, some not taxed at all.
But I mean, an exemption is the same in effect as a lower rate, except the rate is zero, right? And wasn't the General Assembly doing the same kind of thing you're talking about? That is, they were looking at these economic entities that are out there and said, well, we don't want to harm anybody by drastically increasing what they've been paying before. We don't want them to be economically harmed. And that's the same thing the county was doing with your client, which was saying, well, we want to benefit them, so we're going to let them we're going to let them have an exemption. Aren't those kind of two sides of the same coin?
I think they're very different. And the reason they're very different is that the replacement tax was set up with these purposes in mind: revenue neutrality, reduce the tax effect in a competitive environment. But those were related to the LDCs. In other words, these consumers were an unintended consequence of the legislation. The task force committee minutes reflect that. That was set up under statute to examine it. And they said these consumers were an unintended consequence. The replacement tax really does none of that for these consumers. The replacement tax is not revenue neutral as it relates to these consumers. The law was set up to be revenue neutral no matter if the taxpayers went in and out of the system.
Counsel, you just described them as unintended consequences, and I saw that in the brief, but as I recall the record, there were some of these directly connected consuming entities before the statute. Are you suggesting the legislature didn't consider at all that there might be those plus some more in the future?
I think what the record reflects is, well, first of all, I think it also goes to the analysis that if they were so fundamental to the tax scheme, why would they exempt the whole field? I think that if you go back to what the record reflected from the testimony of our expert witness, who was the only expert witness testified at trial, what he said was, when you go back to the history of this tax, it was really focused on the electric generation side. And the fear was that you would have these electric generators on the border states delivering electricity into the state. And so they wanted to make sure that consumers of those electricity generators were paying a tax so that it would compete with the in-state generators. And that got transformed over to the natural gas side. And I do think that it was an unintended consequence that you had this explosion of the ethanol plants, which was not envisioned by anyone at the time in 1999. That would have taken place in the 2000s. And so what you had was these directly connects that were set up in these service areas having nothing to do with a local distribution company or an investor-owned utility. They were simply taking part in interstate commerce, and they're effectively getting penalized for that. And then there's these drastic different rates that occur. And our position was that that was not the intention of this legislator, the legislator to enact a tax like this. And we believe that nothing in the record supports a finding that any of these supposed rational basis apply to these consumers.
As you know, our equality provision in the Constitution, we have suggested demands what we've characterized as equal operation, but not necessarily equal consequences. Isn't your challenge to this tax scheme really based upon your complaint that there are unequal consequences in a situation that is otherwise operating equally across these 55 regions, the service areas?
Your Honor, we don't believe that it is actually operating equally. The consumers are taxed underneath the statute, and then they're forced operationally into these competitive service areas, which have these rates set up that have nothing to do with the consumer. So the rates can fluctuate quite a bit, and it all has to do with the usage of the local distribution companies.
Actually, I'm not sure that I agree with your characterization of forced in the sense that it was entirely your client's choice about where they located, right? And they located in this particular service area with knowledge of what the tax scheme was, correct?
That's correct. I don't think that knowledge waives your constitutional rights. And I don't believe that simply because you have a local group of investors that wants to benefit your local economy, that they have to then go to another local service area just because the law is unconstitutional. I don't think this court's constitutional jurisprudence suggests that. And so that's exactly what happened here. Not only that, but there's nothing in the record that says that Mid-American Energy would even have served them, because when these ethanol plants were coming online, and even still today, Mid-American Energy and other LDCs are very hesitant to build out a multi-million-dollar pipeline to a plant that may not be there in 1 or 2 years. So if they want to benefit their local economy, if they're local consumers, which in this case the record reflects they're all virtually local investors in this, what I think the suggestion is that they would then have to choose the best competitive service area, and we don't believe that that's required under an equal protection analysis. And in this case, even if they had chosen what was the lowest tax rate CSA jurisdiction at that time, it would have been the highest today because of how the rates flipped. So it's entirely impossible for a consumer to choose the best excise tax environment for them under this law. And so that's why we say that they were somewhat forced into this taxing scheme, because they chose to do business in a certain way. And that's what we feel is violative of the Equal Protection Clause. And moreover, even with...
Can I jump in? Has our court ever struck down a tax differential based on the Dormant Commerce Clause?
Has the Iowa Supreme Court? I don't believe so.
And it's, I'm sure, well, one of my issues with your position is that our court traditionally has been very deferential to tax differentials the legislature enacts, and why shouldn't we have the same sort of hands-off approach here?
Well, to clarify, the Dormant Commerce Clause is it's a cumulative effect of government operation, similar to the U.S. Supreme Court did in Associated Industries of Missouri versus Lohman, where they analyzed a tax levied in conjunction by local and state taxes. So it's not so much that we're challenging the disparate rates of tax in the Dormant Commerce Clause perspective. In the equal protection analysis, the court did in Racy strike down disparate tax rates when it held that the rational basis did not survive an analysis that's based on fact. And here, I think we have the same thing. In other words, here the rates of tax vary drastically, and sometimes that gets lost in this case because it's decimals. And so you think, well, what's the difference between 0.0001 versus 0.0004? Well, that's a factor of 4. I mean, no other tax in Iowa varies by this extreme degree. We're talking multiples of 23%, to 100% increases. Some are in 0 tax rates because they're unusable. So I think what makes this case different is the extreme degree of disparate tax rates levied on taxpayers.
The department is suggesting that one of the rational bases for these classifications that result in the disparate rates that you're just talking about was the notion that the objective was tax continuity, and they didn't want to be turning the local government's revenue pictures upside down. Why isn't that a rational basis for these service areas?
Well,
and different rates within them.
It certainly is. I see my time is up. May I address your question? It certainly is a rational basis as it applies to subsection 1 of 437A as it applies to LDCs. I mean, it was based on their historic tax revenues. It's fairly revenue neutral for the LDCs, the local distribution companies. The problem is what basis does it have on the consumers here? The consumers came in after the tax. Their terms really don't affect the rates very much anyway, if at all. And so it has nothing to do with revenue neutrality. If Little Sioux went to local property tax versus replacement tax, the competitive service area would receive the exact same amount of money. It really has nothing to do with revenue neutrality as it applies to consumers. All those rational bases apply to the suppliers, the LDCs, not the consumers. Thank you.
Thank you, Mr. James. Mr. Stanley.
May it please the court. This court should affirm the district court decision in this case because the replacement tax does not violate the equal protection provisions of the Iowa Constitution or the U.S. Constitution and does not violate the Dormant Commerce Clause of the U.S. Constitution. There is a rational basis for the replacement tax. According to this court's holding in the Quest case, when considering tax legislation, whether tax legislation comports with equal protection principles, we apply the rational basis test.
Yeah, but in the Quest case, we applied the rational basis test as set forth in RACI. I mean, it's not just conceivable, it has to be more than conceivable. How does your analysis go against the way we applied it in RACI?
Well, I think, as you said, Justice Wiggins, the Quest really adopted a couple of these tests, even though it's a very deferential test, adopted a couple of the RACI principles, which is that it has to be a realistically conceivable justification that doesn't involve extreme degrees of over-inclusion or under-inclusion. And the other thing that was RACI and Quest was that the justification for the disparate treatment must be credible and not specious.
So how does this rational basis proposed by the state meet those requirements?
The way it meets those requirements, Your Honor, is that many times we have to look back in hindsight at a statute and speculate about the reasoning for the statute to test that. But in this case, right from the beginning, the reasoning was put in the findings when the acts were initiated in 1998 under Section 1194, Section 1 of the acts. And the entire findings are found in the record at page 14 and 15 in the ALJ's proposed decision. It's quite lengthy, a couple of pages of findings. But the district court...
ALJ rejected RACI. I mean, the way I read his or her decision, I don't know which it was.
Well, that was part of it, but in terms of putting the findings in the record, what I'm saying is there were 2 pages of findings right from the beginning, which is somewhat unusual to have that rational basis right up front in a statute. And the district court in this decision summarized 4 of the findings that do relate.
I understand the findings, but tell me how the findings meet the RACI test. How is it more than just conceivable? It's actual, the test you just gave me.
Well, it's more than that. When the district court examined it, one of the things that Mr. James said was, and I think they've conceded this in the brief and certainly today, that they concede there's a rational basis for the replacement tax as it applies to the local distribution companies. And so their attack now is limited to just the rational basis for them. And I think there are a number of ways that there is a rational basis for treating them. One is right in the plain language of the findings, where it talked about preventing competitive disadvantages that may arise under the existing tax structure. And that certainly applies not just to the LDCs, but to these bypass customers as well. Second, in the general,
Would you stop with that one? And just clarify for us how that particular basis that you assert as rational actually has a basis in fact on that particular prong.
yes, just a sec. As the district court said, but for the inclusion of the end customer backstop in 437A52, which is the part with the bypass customers, the natural gas that passed directly from the interstate pipeline to a consumer would not have been subject to any delivery tax. The legislature could reasonably conclude that allowing for this disparate treatment of the distribution of gas would result in a decrease of the available tax base for the excise tax and reduce revenues for local government, which was one of the questions you asked Mr. James.
So would it be correct in your view to say that what they're really saying there is if we don't levy the replacement tax on an entity like Little Sioux, that everybody's going to directly connect, and fewer and fewer people will be buying from the LDCs, and there will be adverse consequences? Is that part of the argument?
Yes, part of the argument, and this is in that General Motors versus Tracy case that Little Sioux brought up on the Dormant Commerce Clause provision. But if you look at that case, which came out from the U.S. Supreme Court just a year before the replacement tax was enacted, there was a history of natural gas use in the United States, and they highlighted the fact that the courts and the Congress, the federal courts and the Congress, had been very deferential about natural gas regulation by the states, especially as it applied to the local distribution companies. And the rationale for that, they even compared it to McCarran on the insurance and leaving the field open for the states. But the rational basis for that and the reason for that is that the local distribution companies have to serve the entire market, whether they're profitable customers or not, whether they have to carry people during the winter that can't pay their bill. They're regulated in all 50 states to provide service, and those sites, including our site, is in that General Motors case. To our
So, Mr. Stanley, and I was listening to Mr. James' argument as well, and I as I understand it, they're not now challenging the discrepancies between these 50-odd zones around the state. Is that right? They're just challenging the fact that that they're subject to the tax in the zone that they happen to be in. Is that right?
Well, he said that at one time, but he was also saying the drastic differences in the zones was a reason why it was irrational. And so I don't know how you can concede we're not challenging the zones and then argue that.
I mean, to the extent that Little Sioux is saying, well, we should just be subject to a property tax. We shouldn't have to pay this replacement tax or this excise tax, whatever it is that the LDC customers pay. Isn't that kind of like somebody who orders something online from Amazon and says, well, I shouldn't have to pay sales tax on that because I ordered it online? Right now they don't, but it wouldn't be unconstitutional to make them pay sales tax if Congress authorized it, right?
And that's our argument. As you were talking about with the location of the business and knowing up front, what was going on, they tried to get under in the reply brief under the Varnum decision about people moving into the state, knowing that it's not analogous to Varnum. It's more analogous to if a business relocated from Mount Ayr to West Des Moines to receive a package of tax incentives and then said, and by the way, the Mount Ayr property tax rate should be thrown in to boot. I mean, if you take a deal to get into something, if the municipals were such a great thing, there's only one municipal plant in the entire record that's a bypass customer, and here it's the Poet plant in Emmitsburg. If it was such a big deal, we'd probably have more in the municipal areas. And that gets to another of the racy arguments.
Can I interrupt you for 1 second? You're not asking us to overrule Racy.
No, not at all. We don't think you need to.
We don't need to, because if you apply RACI, you think you can meet the RACI test.
Like on municipals, for instance, on the RACI test is extreme degrees of over-inclusion, under-inclusion. When you have one company in the record who is in a municipal area, that's not extreme degrees of under-inclusion, over-inclusion. And
My real question is, I think it goes along with Justice Mansfield. When we do the rational basis test, do we do similarly situated with people in the district or similarly situated with people outside the district? I mean, that's the question I have, and I don't know.
we argue that Little Sioux is similarly situated with the people in its competitive service area. And this court and other courts have said you don't need geographical uniformity as long as it's not arbitrary and capricious. And it's not arbitrary and capricious to have the differences here. They spelled them out in the statute. If they had had a uniform rate, then there would have been a lot of taxpayers who would have had their rates reduced and a lot who have had them increased. It would have affected the revenue of local governments. And so in order to have revenue neutrality, which is one of the points the district court order made, for utilities, for customers, for local governments, it was established in the way that it was.
Couldn't the state have, when they did this statute, have one rate for the whole state, and then to compensate the districts that got less money than before, have the state collect the money and redistribute it back to the county, to the different service areas?
They may have been able to come up with a different formula, but the issue is whether this formula not is the best plan, but whether it meets constitutional muster. And so there may be other systems that they could have done that would have also passed constitutional muster, but our argument here in the deferential rational basis plan or review is that this meets constitutional muster. There are a couple of things I wanted to make sure you knew about. They talked about the volatility of the rates. The district court found that Little Sioux's rate remained relatively stable. There's also the evidence in the record that because some service areas at the beginning weren't fully reporting their deliveries, there was a change. Once those happened, the threshold adjustment was done. But in Little Sioux's brief on page 35, they say that they went from the third lowest non-municipal service area rate in 2003 to the third highest in 2011. And while I think that may be technically true, if you look at page 285 of the record or the code, you see there's only 6 non-municipal areas, service areas. So that really means third lowest to third highest means over an 8-year period, they went from fourth to third. That may not sound as drastic as what they've been talking about. They also say that this isn't rationally related to the value of the pipeline. This is not a property tax. It's an excise tax. It doesn't matter if Little Sioux's pipeline was solid gold. They'd still pay the same rate on the therms. It wouldn't matter if Mid-American got rid of half their operational property or doubled their operational property. The therm rate would stay the same. It has nothing to do with the value of the property. And they misunderstand an excise tax. This tax doesn't even have to do with the price of the natural gas going through the therms, no more than the gas tax in Iowa. It's the same rate for gas tax, whether gas is $2 a gallon or $4 a gallon. It doesn't have anything to do with the value. The excise tax is a tax on the privilege of doing business. It's not an ad valorem tax on value. And I think that's one of the major misunderstandings that they have in this case, and one of the reasons why their alleged harms are not that significant. Also, in terms of them locating where they wanted to, the district court said that was another rational basis that the legislature could have had for including future direct connect customers in the replacement tax, is because they made this decision after the tax came into effect. They don't realize that tax neutrality, what that means, revenue neutrality and tax neutrality means to the people who are already in business. It doesn't mean that if you paid zero tax before you were a business, you should pay zero tax after you were a business. That's not the concept of revenue neutrality. And they talked about the grandfather companies. One, there were only 5 of them. And secondly, this court has said that there's a reliance interest in how this was done again, but done before. And again, that's a difference between Little Sioux and the 5 grandfather companies. As the district court noted, they had already made the investments, they had already picked their locations, they had a reliance interest. And so for Little Sioux to say, no harm, no foul, we just like to be treated like them, that's just not the way that it works. If there's a new tax, they don't have a reliance interest in having it done another way. Let me just talk briefly about the Dormant Commerce Clause and say that if you look at the General Motors Tracy case, you'll see that they're very deferential on that. They were, even where in that case GM had standing because they paid an extra tax. These people don't pay an extra tax, they pay the same as everyone else. There's no standing, and their harm is a harm alleged to happen by Mid-America, not by any state agency or regulator. Thank you very much.
Thank you as well, Mr. Stanley. Mr. James.
May it please the court. First, I'd like to address the issue of that Justice Mansfield you raised about the CSA issue. The replacement tax as a whole encompasses the CSAs. We certainly believe that it's unconstitutional for one consumer of natural gas to pay a low rate or a zero rate of tax in one CSA and then pay a drastically higher rate of tax in another CSA. So we are challenging the fact that different consumers without the state pay different rates of tax. I mean, that's certainly one of our arguments.
But how
we
are
don't.
you similarly situated to the other CSAs? I mean, the tax bases are different in every one. The conversion rates are different for every one in order to get the tax base. So how are you similarly situated to another CSA to make this comparison?
I think that we're similarly situated in virtually all regards. We consume gas the same way. We make the same product. We market that product in the same market. So I think that we're similarly situated in all aspects, except the point that we claim is discriminatory. So in other words, as the Varnum and
You have to look if you're similarly situated based on the purpose of the tax. And the purpose of this tax was to keep the property tax level in each CSA. And so I just have trouble, and maybe I'm wrong, been wrong before, I guess, but you know, how are you similarly situated to somebody outside the CSA when you're trying to equalize property tax in a CSA? I mean, that's the purpose of it. I mean, in Racy, there was no difference between the gambling boats and the river boats and land-based because the purpose was to raise a tax on casinos, on gambling. This purpose is not to just raise a tax. This purpose is to equalize the property taxes in the CSA. So am I wrong?
Well, I think we're sort of in a win-lose situation in this regard when the department criticizes us for saying, well, it's based fundamentally on a property tax. And then they say, well, you don't understand the difference between excise tax and property tax. And then we explain, well, no, it is an excise tax. And then we say, well, you're not similarly situated because it's a property tax. I mean, I think that's the problem with this tax. It's an odd tax. And it was based originally on replacing property tax values of local distribution companies. These consumers came in there. Regardless of if these consumers ever came in there, the property tax would have stayed the same. And in fact, the property tax would have been theoretically even increased in some instances based on the property tax revenues received, based on the value of these pipelines coming in. So I think that we're similarly situated because we have nothing to do with property tax neutrality. I mean, that has everything to do with how the tax was
My point
calculated
is that
in
was
the
the
first
purpose
place.
of the statute, and that's what you have to look at when you start seeing if you're similarly situated. the purpose was to make sure, and Iowa has rural and urban areas, they have areas that have great property tax, they have areas that generate little property tax. And that, you know, you're not claiming, are you, that within your CSA, you're treated unequally, are you?
Well, I think to a certain extent we are. And that's the fundamental point of our Dormant Commerce Clause, is that
That's not an equal protection, that's a Dormant Commerce Clause case.
Exactly, but I don't think we're necessarily even treated equally, and that's a fundamental part of Dormant Commerce Clause is fair treatment. So I think that even within the same CSA we are, and again, it's different from complaining about different property tax levy rates, because those are local taxing jurisdictions. Here we have one taxing jurisdiction, that's the state of Iowa. And the state of Iowa is deciding how two similarly situated consumers of natural gas should be taxed, based solely on the historic property tax values of the local distribution company. And I think this court and its decisions, and recently in Quest and in Varnum, have always been hesitant to end the constitutional analysis that's similarly situated, because virtually every case could be decided on those grounds, because there's discrimination, there's differences. So I think that that similarly situated argument here would best be served by looking at the fact that...
Let me try another hypothetical on you, Mr. James. Let's say the General Assembly meeting over there this session decided, you know, we think state income tax is a bad idea because it taxes work and productivity, and therefore we're going to replace the state income tax with a state property tax on individuals. But they said, well, it might be unfair because in a lot of the rural counties you have very valuable farmland, but people who have relatively low incomes and have been paying relatively low income tax. So we're going to impose in those, we're going to equalize, and we're going to have a lower rate of property tax in those counties than we do in, say, more urban counties like Polk County. Would that be constitutional?
I see my time is up. May I address your question? Yes. I think the differences here is it's kind of hard to address that question because historically the state has never had much impact on levy rates within different taxing jurisdictions. So it'd be a wholly new area of taxation for the legislator to get into. But if they did and it was related to the taxpayers and their activities, I think there could be some basis for it. Here, it would be in a similar situation saying to someone else, well, because someone has a big farm down the road, you're going to pay the same rate of taxes they do, regardless of whether you own a farm or not. And I think that would be part of the problem here, and that's what we're complaining about here. Thank you very much.
Thank you as well, Mr. James. The case then is submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.